Hello, good evening. I would like to welcome you all to this evening's licensing subcommittee. First of all, could I just ask that you all put your mics on mute, please? Thank you. Only speak when invited to do so by the chair. If you wish to speak, please raise your hand and direct all communication via the chair. Please ensure that your mics are muted when you are not speaking, apart from the chair, who does not need to mute their mic at any stage. And this is to ensure that the meeting is conducted effectively. When speaking, please be succinct and do not exceed the allocated timeframes. If you're referring to a page or picture in a report, please be specific. If you are having technical difficulties, please use the chat function in Google Meet to alert the meeting, and we will seek assistance for you. Please do not use the chat function for putting formal questions to the subcommittee. Any persistent disruptive behaviour will result in removal from the meeting. Once all applications have been considered, any remaining parties will be asked to log out of the hearing. Please could you do so promptly so that councillors will have the opportunity to deliberate and to make a decision on each application they have heard. You will be notified of the decision within 5 working days. However, if you contact the licensing service tomorrow, you will be given a skeleton decision. At this point in proceedings, I would like to hand over to members to elect a chair. Thank you.
Can I nominate Councillor Peters?
And I agree with that, seconding that.
So thank you. I mean, this is a resumption of the previous meeting, and I was chairing that meeting, so happy to continue to do so. It is a resumption, but I'll ask whether there are any absence. Okay, that was a no.
No, none reporting, Chair.
Okay. And any declarations of interest from any of the members? No. Usually we look at minutes of the previous meeting, but there aren't. Usually at the beginning of these meetings, we make reference to the licensing subcommittee hearing procedure, which I think we all should be familiar with, given that we went through that at the beginning of the previous meeting. Now, for this meeting, as advertised, we have 2 items. One is the application for a personal license, and one is the resumption of hearing for the application for a review of the premises license of off-Broadway, 63, 65 Broadway Market. Now, we're going to flip those items, so we will hear the application for a personal license after we continue to hear the review application for off-Broadway, and in large part that's because of the sensitive nature of some of the information around that personal license application, so we will have to hear that in the closed session, rather than having the relatively large number of people who would like to or are present in order to discuss the off-Broadway review application, rather than asking them to go away and log back on later or stick around. We thought it was fairer to you for us to hear the review application first, so that's what we're going to do. Now, in the how to do this? We have Mr. Hughes. You're here for the licensee, rather. Is the licensee here as well?
Yes, sir, he is. I can't see him on my screen, but he has been here.
Okay.
I am in attendance.
There he is.
Yes, you're Broadway. And then we also have a number of other people, including Mr. Tewitt from the Licensing Authority. And Mr. Tewitt, you've brought this application, and Mr. Gardner as well. that right? Are you both here?
Yes, I am here. Yeah, I was the individual that brought this particular application forward.
Okay. And then we have a number of and we also have BC Kerry Ryan from the Metropolitan Police Service. You're here?
Yeah. Yes, I'm here.
Mm-hmm. And then a number of, and then Louise Braywood, who has sent in further submissions to supplement submissions that you sent through previously, and that you've done in your capacity as the chair of the London Fields user group. You are here.
I believe Kevin is joining us in a bit. He's got held up because he didn't get his invite till 7:04.
Ah. And Kevin is another resident.
He's a resident, not directly here, but he's had complaints via residents that to the London Fields user group and the impact in the local area. We have submitted a witness statement.
Is Kevin the chair?
Yeah, he's the chair now. The chair. He was the secretary. He's now the chair.
And your capacity in that group is what? Sorry.
Well, first of all, I'm a normal member of that group, but I also am because I'm on London Fields. Because I'm the chair of London Fields Safe and Neighbourhood panel. I am on that committee. So we do safeguarding issues or crime and antisocial behaviour issues, and we liaise between the council and the group. So that's my role there. Okay. But I love the fields, and that's my main reason for being a member there.
Okay. Thank you very much. We have Mr. Bridge as well.
I'm a local resident, Chair.
Okay.
I was brought as a witness by Louise Braywood.
Okay. I think we're going to Mr. Hughes. I think you'll have something to say to us about the witnesses that Ms. Braywood has brought. But before we come on to whatever you want to say to us, I'll just run through the other people on the call. Ms. Bowditch, you're here as well.
Yes, I am. I'm resident 2 Jericho, immediately behind Up Broadway. Here is a local resident, witness for Louise Braywood.
Okay, and Mr. Grocock.
Hi there, I'm a local resident and I was here last time as well.
And actually you're here, you made a submission representation yourself, so you're not here necessarily as a witness. Okay, thank you very much. So in the intervening, to recap where we got to at the end of the last session, we asked the license, Mr. Bridge.
Apologies, Chair, just in case it's relevant now. Just before, regarding your earlier comments about putting to the back of the discussion the sensitive nature of the personal license and the DPS, may I just clarify though, because it's relevant to the preceding discussion. I understand there has been some discussion around whether Mr. Selby has a current personal license and whether he is the DPS holder, because if he's not, then that's obviously highly relevant to, would indicate unlawful sales and so forth over the preceding period. So could I just make sure that that link is understood and just ask for any clarification of that?
Yeah, absolutely. The other item that we're putting off to afterwards has no bearing on this application, but the question of the designated premises supervisor is something that we intend to address during this this meeting. So where we got to last time was that we had asked the licensing authority and the licensee and the Metropolitan Police and residents to go away and engage in what the licensee had said that they had tried to engage in previously, which was mediation. So in the intervening time, we have received a number of representations from the LFUG and for the London Fields User Group, Ms. Braywood, and we have also received a set of conditions, supplementary or condition changes. Now, just deal with the conditions first of all. Have they been agreed with all those parties that I just mentioned, Mr. Hughes?
So they've been agreed. They've been agreed with me, yes, so my client. I just need to meet a few more submissions on other, if I may.
Well, we'll come back to those in a second. They've been agreed with you and your client. Maybe Mr. Gardner. Have these conditions that have been put to us been agreed with the licensing authority, the licensee, the Metropolitan Police, and the residents?
These are a set of conditions that were drawn up between ourselves, the premises, and the Metropolitan Police were also in on that meeting that we had. But we have obviously, some concerns to address on that. I think that Mr. Hughes needs to say something about the structure of the meeting. I'm not sure if we need to clear that first, though, Chair. I'm sorry.
Well, I'd like to cover this point first because we sent people off to mediate.
Yes, the
to
adjournment was, yeah.
To agree a set of conditions. And I think what I'm hearing here is that that hasn't happened.
Chair, if I may.
Yeah.
I was in that meeting. We did have a meeting. We did sit down and discuss some conditions. Some conditions have been drawn up, which I believe have been submitted. The police are not in agreement with all of those conditions, but we are with some.
I think, well, thank you very much for that. I think the issue broadly is whether the residents have been included in that discussion. And there are a lot of shaking heads here. And I think we were pretty clear that that's what we expected to happen. Is there a reason why that hasn't happened, Mr. Gardner?
No particular reason, but of course there would be the possibility that this meeting, those conditions would be aired, and they could be gone through in the meeting and with the committee to make a decision on what the final conditions, if that's to be the case, would be for the premises to go forward and operate. This wasn't cooked up in a back room. This was a set of idealized conditions, but there have of course been developments since then which we do need to go into, and I can speak on those if you wish.
Not right now. We'll come on to that in a second. Was there any attempt to share these conditions with residents?
Not until this evening's hearing, no.
Okay. Mr. Hughes, are you aware of any reason why this mediation that we asked to happen with residents didn't happen?
No, sir. I mean, I take the same view as Mr. Gardner, and on this one, that we meant to formulate a set of conditions. We had our own conditions that we put to Mr. Gardner and the police. They came back with further proposals, and then we met and discussed them. My understanding was along the lines of Mr. Gardner that we were going to bring these back to the committee so the members and others can have a look at them and criticise or comment.
So, I mean, this all arose from the licensee telling us that he had tried to engage in mediation with the residents and that wasn't successful. So we asked you to go off and talk to the residents about these and come back with a set of conditions that everyone was happy with. I think we were clear in saying that.
There was never any suggestion, sir, that he had put out feelers with residents about a mediation. It was something that he had himself considered at some point. And I was advising him on that, but that proved to be far too expensive for him to engage in as a proposal. I don't know why everyone's laughing and jeering, sir. I was the one who was there advising him about mediation, and it was an enormously expensive process to go through, and it just became too much for him to afford. Frankly, we took the name of an individual mediator and the prices that he was giving us to mediate, and I'm a mediator myself, so I'm aware of the costs that are charged. We're in the multi-thousands of pounds.
Okay, I mean, looking back at the draft minutes of that meeting, that I appreciate you haven't seen, there is a suggestion that Mr. Selby had said that he had reached out to engage with an offer of mediation, particularly in relation to, and that offer hadn't been accepted by residents.
No, he hadn't, sir. That was something he and I were discussing. Mr. Gardner, I think, was party to a meeting where we discussed it, but he hadn't put a feeler out to the residents in that respect.
Okay. But in any case, what we had suggested was that you go away with the licensing authority, the licensee, the Metropolitan Police, and the residents to mediate and come back with a set of conditions that everyone could stand behind. Or if you couldn't all stand behind them, you came back and told us that you'd at least attempted to narrow down the issues. And that hasn't happened. And that's disappointing. That is very disappointing that we're all back here right now, and we've got lots of residents who are still very angry, and a set of conditions that haven't been agreed with anyone. Well, have been agreed with the licensing authority. Some of them have been agreed with the Metropolitan Police, but there has been no attempt prior to this meeting to try to narrow down these issues with the residents. Anyway, be that as it may, Mr. Hughes, I think you want to talk to us about developments since the last meeting and other submissions that have been sent to us.
Well, thank you, sir. I'm not sure what the developments are since the last meeting, but I just wanted to address you on a couple of points. I've received further documents from various parties. I know some people took part in the adjourned hearing last time round, but it looked to me as though some of them, and I don't know who they're from because they're all redacted, of course, so we can't tell who they're from. But one or two of them, it may be, are out of time on the original representations consultation period back last year. And I think I've seen an email from Mr. Tewitt indicating that one of them may be out of time in any event. And the second point I would make is that, as far as I'd understood it last time round, we'd actually concluded the evidence. I know what you say, Chairman, about sending us all away, but I think we'd concluded the evidence, and we were all allowed generously by you second bites of the cherry to make our points. So in my respectful submission, the evidence had actually concluded at the last hearing. So now we're discussing these further issues that you sent us away to discuss. I apologize, it doesn't seem to be in a satisfactory way that you had in mind, but I think I came away with the same feeling Mr. Gardner did from the meeting. And we've had a meeting with police and the licensing officer. There are other points that have been raised about Mr. Selby's evidence at the hearing, alleging that he's lying on in many ways. And if you're minded to hear that evidence, then I think Mr. Selby must at least be given the chance to answer those points. And there are allegations about me as well, as the barrister in this matter. The first time I've ever had an allegation against me personally in 30 years of practice. But there's an allegation that I've somehow put a misleading remark or statement in front of the committee. And I think I need the opportunity to correct that as well, if I may. And I think the other issue may be planning, which Mr. Gardner may be raising, may be thinking of, in which case on that one I have submissions to make, as and when you're ready to hear from me, sir.
Absolutely. So I think that we weren't conclusive last time, that the evidence session hadn't necessarily closed, and I think that I understand that it's within the discretion of the chair to allow further evidence from those who had participated in that meeting. I'm also advised that anyone who appeared and had made representations during the period allowed for making representations is entitled to call witnesses, which can be heard at the discretion of the chair. And I'm certainly minded to allow Ms. Braywood to make further submissions and to take into account the submissions that she made, that she sent to us in the intervening time. I will ask, Councillor Fajana Thomas, sorry, you may have had your hand up for a while, and if so, I'm very sorry for missing you.
Thanks, Chair. It was at the point where when you were asking about mediation that I wanted to come in. And the coming is just to ask Mr. Selby whether he attempted to just call a normal meeting, just ask residents to come to the pub and discuss if he's looking at the cost of professional mediation. So I'm thinking residents can always come together and have a community meeting. That was what I wanted to ask. That was there any attempt to do that?
No, sir, I've indicated that it came into the meeting last time around because it was a discussion between primarily myself and Mr. Selby as a possible way forward. And I think Mr. Gardner had been a party to the meeting, a previous meeting, not the one we've just had, when it was mentioned, but there were no feelers put out to residents as such on that.
Mr. Selby, you've got your hand up.
I am chairman of the Local Residents Association. I'm here as much as I can be with the two small children, and no residents approached me asking to speak to me. I'm welcome to have a discussion with anyone at any time.
Mr. Selby, I think you need to speak up. I don't think we heard that.
Sorry, I'll just check my microphone. Can you hear me now?
I can, yes.
I am chairman of the Local Residents Association. I'm always happy to speak to anyone at any time, and I'm in the market as much as I can be, very visibly. No residents have approached me. We did have a discussion about trying to do mediation with Mr. Gardner last year, but I think that stumbled for some reason. I'm not quite sure why.
Okay, thank you very much. I've got hands up from Ms. Bowditch and Mr. Grocott, but from your energetic shaking of heads, I think I understand what you're going to say. Okay, I'm sorry, I won't bring you in right now, I'm afraid. We've got a lot to go through. Ms. North?
Yes, I was just going to ask you, the Chair, I appreciate that mediation is expensive, but was there any consideration for a public meeting, maybe with local residents in the area?
So I think that's what Councillor Fajana Thomas.
That was my question. That was what I asked. Which?
And the answer was no, I think. Mr. Bridge, I'm hesitant.
Super quickly, Chair. I'm interested in this Local Residents Association. We're all local residents. None of us have any communication or hear anything from Mr. Selby over many years. There's people been in this street for 40 odd years. We're not aware of any chairing of an active residents association. I think you just let me leave it at that for now, but I would like to pursue that if it's pushed by Mr. Selby as an active.
Yeah, I don't think that's going to be material to any deliberations that we have here, so I'm going to leave that to one side for the moment, I'm afraid. Okay, right, so where we got to is I'm minded to allow Ms. Braywood to make further representations to us on the basis of the submissions that she sent in, and subject to what Councillor Root and Councillor Fajana Thomas say, and Ms. North to allow her to call witnesses as well. Are the other panel members happy with that? Mr. Gardner, I'll come to you in a second. Councillor Fajana Thomas? Thank you.
Sorry, Chair. Do you want me to come in on the point on?
Yeah, on the suggestion that Ms. Braywood A, speak, and B, can call witnesses.
Yeah, I'm in support of that.
Councillor Root?
Yeah, I am supportive of it. The only thing I'd say is that since this meeting went on till extremely late last time, I'd really impress upon Ms. Braywood that we don't want to be hearing witnesses who are just saying the same thing that she's saying. So if she's able to make the point for them and feels that we can move on a little bit more swiftly, that I think everybody would probably appreciate that.
Yeah, absolutely. Mr. Gardner, you've got your hand up.
Thank you, Chair. As the applicant, I would like just a few minutes a couple of minutes to address the committee on the findings and on the conditions that we drew up with the applicant, with the premises owner and his applicant and police.
Absolutely. Well, we'll come to that probably next, and that will help Ms. Braywood with her submissions and representations. Mr. Hughes.
It's the obvious question, Chairman, whether Mr. Selby and I will be able to respond to that evidence.
Yes, yes, you will.
We're being somewhat out of kilter from our last hearing, which, as the Councillor said, did go a long time. So if we could have some opportunity to respond, then so be it. I've no objection at all, I must say, to Ms. Braywood making her remarks. It was quite clear she was here at the last meeting, and she put before the committee why she was here. So I don't have any objection to Ms. Braywood. It was just some of the other statements that had come in who I couldn't tell who they were because they were redacted, and the council won't tell me who they are.
Okay, and I do think it's appropriate for you to be able to respond to anything else that you hear. So, Mr. Gardner, could you talk to us about the conditions that we have sent to us?
Yes, I don't want to go into length into the individual conditions themselves. These were agreed by ourselves and the police, and I know the police haven't agreed to all of them, and with the licence holder. However, there have been some developments which I think really have put into question whether or not we can go forward with these in their entirety. And certainly, the two that I'm principally concerned about are the one concerning the designated premise supervisor, or the DPS. At the last hearing, we heard from Mr. Selby that he was in fact the DPS, and as the previous applicant had left, or the previous holder of that office had left. We've looked at this, and there's actually no record of application from Mr. Selby. We haven't taken payment from it, and neither I understand the police have also not received anything from him. So therefore, technically, there is a sort of, as it were, a name on the licence for as a DPS. But of course, we don't know what the position is. We've never had a letter of resignation, for example, from the previous occupant. So it would appear to be that from what Mr. Selby says and what the paperwork says are two different things, and that really needs to be kind of sorted out clearly, because it's a vital position within the business. And as I think it's already been remarked, alcohol sales are not lawful without that person being in place. However, this is maybe a technicality, I don't know, but that needs to be addressed. Also, the planning permission, it came to us rather late actually, and I was fortunate for one of the residents actually giving the name of one of the licensing officer that the officer that was dealing with this, and I spoke to her from planning, and she explained that in fact the planning permissions are quite clear and have not changed for some years. That the lower part of the lower premises, which is described as an art gallery, should operate from 10 a.m. to 4 o'clock in the afternoon, and then the wine bar, which is as it was described and still is described in planning terms, should be operating from I think 4 o'clock and through until 11 p.m. At which point the premises should be closed. And there's been no change since that. No change since that time. There was a brief respite given to the premises in 2011, where it was allowed to operate at a later or close at a later hour, midnight. But this ceased in March 2012. These two factors, could have been told to us a little bit earlier, and has caused us a lot of work actually in terms of and concern, obviously, which we will hear about no doubt from the residents. And I really do think that it sort of brings into question whether or not the premises can frankly sort of observe the sort of conditions that we've actually sort of imposed. And I'm sure you will hear from Mr. Selby and Mr. Hughes on that point. And I think that it may well change the committee's view as to what solutions they provide to this, and whether or not they what those may be. I really think you might have to decide very carefully on the evidence that you hear now as to what the next sort of move should be in relation to the premises.
Thank you very much for that. That's very helpful. On the DPS, did you say that there had been the resignation of a previous DPS, but you hadn't received a resignation letter?
We haven't received anything from the previously named DPS to say they are not the DPS, if you see what I mean. And I think it's part of the process that we would expect to have, certainly from a resignation point of view, a notice of them with a signed sort of piece of paper saying that they actually are resigning as a DPS, and we haven't had that.
Do you know when that previous DPS stopped being the DPS, or supposedly?
Well, No, Mr. Selby would be able to provide you with that information.
Mr. Selby, I will come to you in a moment. I just want to ask Mr. Gardner a few more things. So, Mr. Selby hasn't told you when that previous DPS stopped being the DPS.
I think he said in the hearing, he gave a date in the hearing as to when that DPS sort of moved, but we haven't received any official notification with which to change the license from any time really.
Okay.
We have his what he gave in the committee at the last hearing, and where he informed us that the DPS, and I think subsequently I've heard from him as well. Now this may well be, I'm sure there are maybe technical explanations for this, and it may be a misunderstanding, because there isn't really anything to be gained for, as it were, not being sort of lawful on this. But obviously it does sort of, one wonders what on earth, what was happening here to a certain extent, as to why those things couldn't properly be observed, because it is a lawful requirement.
But it does go to your point about whether compliance with the law, right, and with licensing rules.
Well, that's for the committee. So that's for you to determine as the committee.
Yes.
But clearly, it is a very, very important rule within licensing, as I'm sure Mr. Hughes will also explain, that it is a vital central plank and pillar of the licensing regime.
And you're saying that there was a suggestion that there had been a new DPS application in Mr. Selby's name, but that the licensing authority hadn't received that. Is that what you're saying? No.
We haven't received anything from them.
You haven't received anything from him? No. Okay. And then just...
Nor have we received, we checked payment records as well, and we would have cleared the payment, and also would have had to go through the police, and they have not received that notification either.
How does one apply for it? Is there an online form? Do you post something in? Do you email something in, or all of those are possibilities?
Yeah, it's quite a technical matter to fill in a form, which then comes to us with payment that is then passed to the police. The police check it for criminal records and so forth, and we check for the fact that there's a premises license, that the person has a license to do so, and then it is then just normally a sort of technical switch that wouldn't need any further sort of ado, really. It certainly wouldn't come to committee. It would just be a technical move from one DPS to another.
As we spoke about last time, the law says you have to have a designated premises supervisor in order for you to be able to lawfully sell alcohol.
That's right.
And it's the responsibility of the person running the premises to ensure that they have a DPS in place.
Absolutely.
Okay, Councillor Root.
It's just a question to Mr. Gardner about the application for DPS. When you say it's a form that has to be filled in, is it an online form? And once it's been filled in, do you get some kind of receipt that you've actually filled the thing in?
Yeah.
Okay. So in other words, one would expect that Mr. Selby would be able to produce such a thing had he actually filled the form in.
I've actually asked him to send me forward the application and any proof of payment, but as far as I know, he hasn't been able to produce that for me. But we certainly haven't taken payment for it.
Councillor Shannon-Thomas.
Chair, my question has just been asked by Mr. Gardner. That was going to be my question around have we asked Mr. Selby to produce evidence that this has been done. Thanks.
Thank you. Mr. Selby.
Could I just come in first, if I may?
Absolutely.
On the legalities of it, there is a DPS currently on the licence. It's Mr. Byron Knight. And Mr. Gardner has quite rightly pointed out there's been no resignation from Mr. Knight. And until there is such a resignation, he is still on the licence as the DPS. So there is a named licence holder at the DPS at the moment on the licence. In terms of the applications, I'll leave that to Mr. Selby to explain the procedures he's gone through.
Just on that, sorry. Presumably, the responsibility of the DPS is not the requirement to have a DPS is not just to have them registered, but also for them to be overseeing the premises when it's running, right? It's operating.
No, it's the point of the DPS is clear. That's one of the functions, clearly, and in many cases it is. But there are many instances where DPSs are not present on premises for a greater part of the time. For instance, I've got many multiple tenanted premises that I act for, and the DPS on, say, 13, 14, 15 premises is exactly the same person. That individual is not on every premises all the time.
So my question isn't so much the physical presence of the person there, but they have to perform a role in overseeing the licensable activities, don't they?
Not necessarily so, sir. Of course, ultimately, the person who's named on the license as the DPS can face criminal penalties if there is a breach of license conditions, him or herself. So they are still liable. Mr. Baron Knight is still liable as DPS on this premises.
Okay, thank you. I've got Councillor Rood and Councillor Fajana Thomas, but Mr. Selby, I think you wanted to come in first.
I sent Mr. Gardner an email on the 14th of March with the original application.
You are a little quiet as well, sorry.
Sorry, I don't know what's up with my microphone today. Can you hear me now?
Yes.
I sent Mr. Gardner on the 14th of March in direct response to his email a copy of the handwritten application for DPS, which was made by my manager on my behalf, who's downstairs actually, and I can get hold of. And he also personally paid for the £24 fee, which I then reimbursed him through expenses. So that's probably why Hackney Council can't find a reference. Hackney Licensing and Planning, as everyone's aware, had numerous problems with their computers over the last couple of years, and I think this has gone missing. The date of the original application was February, when we were closed, as Mr. Knight then left my employ at that point. That's February 2021. I never got an acknowledgement of the DPS form, but Hackney Council were having problems with their computers at the time, so I wasn't surprised, but certainly was submitted in February 2021.
So there was a well-planned, extensive and malicious cyber attack, which is, I think, what you're referring to. You made how was the application made? You say it was handwritten, so it was delivered to, posted to the council?
It was scanned and emailed to the council. I have a PDF copy. It's a Word form rather than an online form, which is obviously not so good. So it's a Word form printed out, typed in. We actually spoke to David Tewett at the time because I didn't have my personal license number, so he supplied that, and then we added it to the application, and it was paid for and submitted. I think it got lost in the mill in February in all the melee that was happening. Also, obviously, most of the bars were closed down at the time.
And you haven't, sorry, and you haven't got a copy of the email that to which it was attached because the person who sent it no longer works for you?
He no longer works in the format of manager, and unfortunately, we don't have an email for any email records for that period because we had our own cyber attack, unfortunately, and we lost our email history going back pre-March.
Have you since put in a new application, Mr. Selby, though, since your correspondence with Mr. Gardner?
Yes, so I dug out the copy that we had on file and I forwarded to Mr. Gardner on recently on the 14th.
But you submitted a fresh application?
Yes, I have since, having been informed that they've it had been gone missing, I've submitted a fresh application immediately on response to that and paid the fee and filled in the form.
And the issue with that, Chairman, is that as soon as that application has gone in, effectively, unless there, of course, is a police objection within a certain period of time, but as from that point, Mr. Selby is the DPS.
Okay. Councillor Fajana Thomas, you've got your hand up.
Thanks very much. I think again, the question I was going to ask Mr. Selby, I think he just answered it, because this is simple. Yes, we do have a cyber attack within the council, but if we don't have the evidence of your payment and application, that is easier. You should have it on your side or a receipt for payment. So I'm not too sure how that works. If you are saying the council lost it, what have you lost it on your side, as well as was there any follow-up? If you've made an application and you haven't had a follow-up, we've had a lot of people that are following up saying, oh, I submitted this and I haven't heard back from the council, because it would have appeared that you haven't followed up or even mentioned this until this came out from this hearing. And Mr. Hughes, sorry, Chair, addressing Mr. Hughes, 10 minutes ago, you said, or even less than 10 minutes ago, you were saying that, or is it Mr. Barnett, the previous DPS holder, that is still liable? There's still a named person. And a minute ago, you were saying now it's Mr. Selby. Which one is it?
Well, Mr. Byron Knight is on the license, so there's never been a period when there hasn't been a DPS at these premises. Mr. Byron Knight was the premises DPS until Mr. Selby put an application, I think this week, having heard that the last application went awry. I think he's since put one in, for which he has paid the fee, and that therefore takes effect from the minute it's entered into the council. It's lodged effectively with the council. Unless, of course, the police have an objection at some point, and then it doesn't have effect, but the police would then have to lodge an objection. So the minute he lodges it, the DPS, he's on as the DPS.
Ms. Bowditch and Ms. Braywood, I'm inclined to ask you to save up what you're going to say until, okay, Ms. Bowditch, quickly, please.
Thank you, Chair. Just very quickly. We just need to clarify some points here. I've got employment tribunal proceedings in front of me. Mr. Selby, sorry, I've got a 5-year-old too, single parenting. Free to go for it. Fine. Have an ice cream. Yep. Mr. Selby actually sacked Byron Knight from the bar on the 8th of November 2020.
Could you say that until your evidence?
I'm not sure what this has got to do with him being a DPS.
No, just to say that there was an employment tribunal of unfair dismissal, so that may be that was awarded in favour of Byron Knight.
Yeah. There's no bearing on the DPS issues.
Yes, can we come back to that later? Councillor Rout.
Sorry, I think my comments might well serve better in the discussion phase, but I do just want to sort of register my surprise that if it's true that Mr. Knight was sacked, that Mr. Selby seems to have been remarkably unconcerned about the fact that he hadn't heard back from the council about the DPS and the lack of one for a year or so.
I'm going to say that I'm getting licenses back from Hackney and indeed other authorities many months, sometimes up to a year after such applications have been made. And my clients are often jumping up and down saying, well, did the DPS application go through? Say, well, yes, it did as soon as it was lodged, but you don't get sometimes a premises license back for many months.
So, Ms. Shuramana, you have your hand up.
Yes, Chair, I just want to clarify. We received email from Mr. Selby with the DBS application on the 17th of March. So we did reply back to him to say that the form is invalid because there's no valid consent. And we have also asked him to clarify whether the previous application back, which was submitted in 2021, was done through post and the proof of payment. Just for the clarification. Thank you, Chair.
So you received an updated application on 17th of March.
On the 17th of March, but the application is invalid because we have not received any consent, which is the LEO2 form. So we have written back to him today to say that to resubmit the DBS application, and also we have asked him to clarify on the DBS application, which he said that he has submitted in Feb 2021 to provide him with the proof of evidence of the payment.
Okay. Mr. Hughes, do you have anything to say on that?
No, sir. It's sometimes often the case that individuals put in an application form for DPS without putting their own consent. Mr. Selby would have to provide his own consent. He just needs to sign up a form which says, I agree to be the DPS at these premises, and sign it himself, and then it needs to be submitted.
But it wasn't submitted. The application wasn't submitted by Mr. Selby. It was submitted by someone else, but without Mr. Selby's signing consent.
I think that may have been the first application we're talking about. I think the one that we're talking about now is the most recent one that Mr. Selby submitted.
Okay, thank you. Councillor John-Thomas, I'd like to get some clarification on something from Ms. North. Can I do that before you come in, or do you want to come in first? Yeah, Ms. North, it sort of surprises me, this idea that it can be lawful for the premises, the operator of premises, to be able to have a designated premises supervisor on the license, registered on the license, but that's it. You know, there's no duty on the operator of the premises to make sure that the designated premises supervisor is actually performing any supervision of licensable activities on the premises. Is that correct?
No, I don't think that's correct. I mean, I think they do have to undertake a course as part of the requirements, and also they need to, I mean, I'm not saying they have to be there every minute of the day, but they do need to have trained staff or make sure that there is proper process in place. They probably would be expected to be there on certain days at least, but it's not a case that they would just step back, because there is a risk then of the premises not operating correctly, and unless they've specifically designated the management duties to other people.
But that is a duty on the designated premises supervisor. Is there a corresponding duty on the operator of the premises to ensure that there is a designated premises supervisor, not only appropriately qualified and named on the license, but also actually performing the functions that the designated premises supervisor themselves is required to function to do?
As far as I'm aware, that they wouldn't be able to operate if they didn't have the designated premises supervisor on board. So I do think that there is some requirement, when the license is being obtained, that has to be in place.
Mr. Hughes is shaking his head.
Unless the actual license holder themselves is going to be the management.
I've done literally hundreds of these things over the years, and in the ideal case, a DPS would be present, but in many cases, and as I said earlier, particularly in the case of multi-propertied operations, you can often have the owner, who is the DPS, named on all, say, 15 licenses, one of which I've got. He is ultimately responsible along with the license holder. So in this case, the two people who would be responsible are Mr. Knight and Mr. and Mr. Selby, Mr. Selby Senior and Mr. Selby Junior, who are the license holders. So those are the categories of people who are liable. The reason why they introduced the system of resignation was because by resigning, you then clearly knew that there was no DPS at the premises and the authority to sell alcohol had gone. But it also takes the criminal responsibility and the other responsibilities away from that named individual. So very often a DPS will be only too anxious to put a letter of resignation in, and the law places that burden on him to do so, if he wishes to do so. If, however, he wishes to stay on the license, that's a matter entirely for him.
But, Mr. Hughes, I think what you said there was that there is a duty on the designated premises supervisor to ensure that they are performing all the roles of a designated premises supervisor in supervising licensable activities on the premises, but also for the license holder, so Mr. and Mr. Selby. But that hasn't been happening, has it?
Well, Mr. Selby, I don't know. Mr. Byron Knight was certainly there until December, we heard, and Mr. Selby certainly is a very hands-on operator and license holder.
Sorry to interject, Mr. Bridge. You're not actually permitted to put messages in the chat box. Unfortunately, I'm sorry.
I apologise.
I know that you're trying to help. You're not permitted to do that. So it's one of the requirements of the meeting.
I apologise. Okay.
So I'm just letting you know, if you could stop, only because someone will be telling you to stop.
Right, thank you.
Okay, sorry.
Just conscious. I was just I know Mr. Hughes is being brought in and Mr. Selby was brought in, and I was trying not to interrupt, but just pointing out some some major inconsistencies, some very serious legal points that I wasn't able to cover.
Mr. Bridge, I've got other people.
Apologies.
Councillor Fashana Thomas.
Thanks, Chair. It's just coming back to Mr. Hughes' statement again, which I found a little, I was a bit uneasy about it. Again, you were saying to us that until this new application for DPS was made on Mr. Selby's name, that the previous DPS, Mr. Baronet, is he, remained the DPS. But how can Mr. Baronet remain the DPS? Either yourself or your client haven't told you if he has been sacked since 2020 and no longer work in the bar. How is that possible? Somebody that's been away from the bar for almost 2 years, then how can they be, you claim that means they remain the DPS until a new application was made? Is that possible?
Yes, indeed. And as I've said, I've had...
Possible when he's not an employee of that...
Yes, indeed. Yes, indeed. Yes, indeed. On temporary periods, because I also have a license holder's qualification, I've also been placed on an emergency basis, I must add, as a DPS in some premises when they're not operating.
That's not what I'm saying. I do understand that it's possible for to be a DPS for 2, 3, 4 premises, and that you might not be there. You might be going there once a week. That I understand that. What I'm saying is that this individual has been sacked since 2020, or has he been coming back?
Well, that's exactly the point I was answering, Councillor. I was saying that I've often been placed on licenses on a temporary basis only. I've not been employed by the individual, but I've been placed on them temporarily while it's not been operating to get them through a particular legal period. So
can Mr. Selby answer whether he's placed Mr. Baronet since he has sacked him, whether he retain him as his DPS?
So I've got a number of people here, but I do think that is important to bottom out. Mr. Selby, when did you sack Mr. Knight?
Mr. Knight was dismissed on November 2008 and remained in employment, paid employment for another month, working out notice.
Did you say 2008?
Sorry. On the 8th of November 2020. And then he worked through till December when the bar closed. I then tidied up all the paperwork and immediately sent off a change of DPS. And that went through while the bar was closed and not selling alcohol in February. And as soon as I was alerted to the fact the paperwork had been lost, I then reapplied.
Effectively closed until April the 19th, I think, when everything started to open up a bit more. Anyway, Mr. Selby.
Yes, so the bar was closed and we got, it was a maniacal time during lockdown, and we got all the paperwork that we thought sorted out in the lull period while we were closed for 3.5 months.
So hold on, the bar was closed from what date until what date?
I think it was the 4th of January until
2021.
April.
4th of January 2021 to April 2021.
4th of January 21, and I think the 17th of April. I have the direct dates, but that's a rough guide. Obviously, we weren't selling alcohol inside the bar for that period.
And from February 2020, hold on, so from December to 2020 to February 2021, Mr. Knight wasn't performing the role of a designated premises supervisor, or was?
Well, he still was, but I was expecting him to resign as DPS, but he didn't do that. And then I decided to take matters into my own hands and fill in the paperwork myself and replace him.
In that period, did he come to the premises?
Yes.
He was still in and around the premises?
Yes.
And still supervising licensable activities?
No, not directly, no. It was a rather hectic period, and as soon as we conceivably could, we filled in the paperwork to change the DPS to me. There was a lack of a month and a half in that time, and we could have been more timely with it, certainly. But there was a month and a half between Mr. Knight not being employed, and my only excuse, and I apologise to everyone concerned, was the rapidly changing situation with coronavirus at the time, whilst having a very young child.
Sorry. And in February 2021, it was Mr. Knight who made the application for you to become the designated.
No, the paperwork was filled in by the then manager, and he submitted the handwritten application via email, a scanned email, to the council, and paid the application fee on his own credit card, which is why there's no reference to our paying it. As I said, he's downstairs now, so I can get him to come up and
But there are no, and Councillor John Thomas, does that answer your question at all?
It didn't, not really, but because of time, I will say we move on. If that payment is made on credit card, so there will be evidence of that. So if that might solve the problem. If the form is lost, didn't get to Hackney Council lost it, but there will be a record of a credit card payment to London Borough of Hackney on that person.
Okay. So, Mr. Tompkins, I see you've got your hand up, but I think we need to deal with some things here before coming to other persons.
Well, I just wondered whether there was any takeaway alcohol sold from the premises at all during that period of time during the second lockdown, rather than the bar being open.
No takeaway alcohol against them.
Sorry?
No takeaway alcohol was sold whatsoever after the 4th of January.
Thank you. PC Ryan, which bits of the conditions don't you agree with?
Thank you, Chair. Okay, so the conditions that I have here, one of the conditions states there should be no vertical drinking outside after 1900 hours. I don't think there should be any vertical drinking outside the premises at all. I think if there is going to be any drinking outside, everybody should be seated and the numbers of people seated should be limited. The condition after that, between 1900 and 2200, customers in the external front area should be seated at tables, and that goes on. I think between 1900 and 2200 should be taken out if it is going to be the case that people are going to be allowed to be sat outside. I think that off sales should be completely removed. I don't think there should be no off sales just after 1900 hours. I think it should be removed entirely. And what else was it? Oh, the smokers. Currently, it's 4 smokers on the license. I don't think it should be put to 6. I think 4 is plenty. And in relation to the conditions, that's all.
Okay. And if the conditions are amended along those lines, the Metropolitan Police's position is that the licence could remain in force.
Yeah, I think if there's no vertical drinking outside, that was one of our biggest issues, the crowds that were standing and drinking in Broadway Market. So if there's no vertical drinking outside, no off sales, and everybody seated, that would allay our concerns.
Okay. Mr. Gardner, your concerns haven't been allayed by these conditions because of the information that has subsequently come to your attention. Is that right?
Yeah, I think I'm just principally concerned about the what emerged from planning and the position that we were put into by agreeing and carrying on agreeing about a midnight close, whereas in fact that never would or could be allowed. Because I know Mr. Hughes might explain that there are sort of different regimes in respect to planning and ourselves, but however, there is in the policy, it states that that the lower time limit must always be observed. So therefore, I think there's no reason why we shouldn't tie, if this is the decision of the committee, tie closing on the conditions to closing at 11 p.m. and certainly not after. I think it would have helped us a lot had we known from the outset what the position was with planning, but we weren't informed, and I had to actually ask planning themselves about this, and it's quite difficult to negotiate our way through that, because I don't know the personnel involved, and it would have just been very helpful to know also that they are themselves considering some form of action in respect of this because of breaching planning guidance. But that is not a matter for this committee. I just do think that that's something that should be observed, and you will listen to the residents about their concerns in relation to whether conditions are observed or not. But personally, I think that this worried me a great deal when it came to pass that I was not being informed by the premises as to what the sort of position was with planning. And whilst I also seem to understand that actually they knew, so I'm a bit concerned about that.
So I'm sorry to pursue this, but you're the applicant here for the license to be reviewed and revoked. Is the licensing authority's position that the license should be revoked, or is it that these conditions should be placed on the license, potentially amended to align the licensing position and licensing hours with the planning hours?
I've moved away from the position whereby I think we can just do this necessarily with conditions, but I do think that the committee needs to take stock of what they will hear from residents, and also my comments here as to and decide themselves. I think this is a matter for the committee, and to determine whether or not they wish to sort of what action they wish to take.
Okay, I'm taking that as the licensing authority thinks we should revoke the license. Councillor Root.
Sorry, it's just a point of clarification from the police. The seated drinking outside, what time would you like it to finish? Are you saying that you're happy for it to go on until 10 o'clock?
Sorry, I think most of the pavement licenses do go on till 10 o'clock. I think there's limited space out the front of the premises, so if we limited them to possibly 6 to 8 customers seated outside, then I think 10 o'clock would be fine.
Okay, thank you.
Right, Mr. Tompkins, I know you've got your hand up. We're going to come to you to or other person's residence in a moment, and actually probably right now. Now we've spent an hour or so on the sort of preliminaries. We've got everyone's views, or the authorities' views on things. Sorry, Mr. Hughes, you have your hand up.
Thank you, sir. I just wanted to know if you would like me to address you on the planning issue Mr. Gardner has raised. I'm happy to do so.
Go ahead, please. Yes.
When you would wish me to do, but I'm a little concerned that Mr. Gardner seems to be insinuating somehow some desire here to mislead him. We met in good faith. I've known Mr. Gardner for many, many years, and I think he would understand that I never try to mislead anybody. The fact is that the planning situation in this case was not clear to us. Normally one wouldn't allude to planning in putting in an application form. There is no box in the application form which alludes to planning. And Mr. Selby has, and you will hear from him in a minute, no doubt, has gone along the last 10 years since the temporary permissions were granted, assuming that that was the position. He hasn't, by mistake perhaps, 10 years ago, didn't put a planning application in to regularise the position and maintain it on a permanent basis. But that position was not known to me, I don't think to Mr. Selby, understanding planning law, at the meeting. There was some issue raised at the meeting that Mr. Gardner, Mrs. Ryan and I attended, where there was confusion over the planning. It was subsequently resolved after we'd had that meeting, and I'm not fully aware of it and what it is, and I have no reason to dispute what the planning officer said. It must be said, of course, the planning officer has not put in a representation to this review in any event, and had every right and possibility to do so. But again, what I would say on planning is that in an ideal situation, yes, you want to be in compliance with planning, and you don't want to have your building or your premises without the necessary planning permission. But it is not a criminal activity or anything of the sort to be in breach of planning. One can be in breach of planning for many, many years. And in some cases, some people have been in breach of planning for many years and have then had that regularized by a fluxion of time. There has been no subsequent intervening event by the local authority or the planning authority to deter them from that. So the criminal offences, if you like, or the unlawfulness arises from the point when the planning authority serve an enforcement notice on the premises to tell them to stop doing what they're doing. That enforcement notice then usually operates for a period of 28 days, during which time there's an opportunity to appeal it to the magistrate's court. If there is no appeal within the 28 days, then the criminal liabilities arise because you're then in breach of the enforcement notice. And for that, you could be prosecuted. And I've prosecuted many and defended many on that basis. But once an appeal has gone into the enforcement notice, then of course it's suspended pending the outcome of that appeal. So there is no criminal activity as such, or unlawfulness, as it were, in operating in breach of planning or without planning. And indeed, the vast bulk of cases going up to the planning inspectorate at the moment, usually in the case of domestic residences, are retrospective applications, where people have been told by planning officers that the extension they put on their house is too big for some reason, or it's not in accordance with the designs in the area. So retrospective applications, that's the bulk of applications going into the planning inspectorate. So I would like to emphasize that point, so if I may, that there's no unlawfulness. As I've said, many people do operate without full knowledge of what the planning position is for many years. And a planning officer may come along subsequently and say, you can't do that, and enforcement notices are served. I understand from Mr. Gardner's intervention that they may be considering the service of an enforcement notice, and they have options in that. They might choose not to enforce if a planning application is submitted, and then the public, the residents here, will all have an opportunity to comment upon that, or it might be appealed and go into suspense. But at the moment, we haven't had such a notice, so we don't know what that position is from the planners. But I would ask you to take that into account, sir, in your deliberations. And Mr. Selby, should probably speak for himself, I think has just gone on for all these years, blithely unaware that he lacked the planning permission to do this. I see people laughing. I don't think it's helpful to laugh. I'm putting this point perfectly seriously to you as committed as the chairman. Thank you.
So regardless of whether a criminal offence has been committed or not, compliance with the regulation is important. And it is important for the deliberations of this subcommittee as to whether or not the licensee is capable of complying with the regulations that apply to it. So I think it is perfectly proper for this subcommittee to take that into consideration, unless Ms. North tells me otherwise. So now I think we probably need to hear from Ms. Braywood. It's been some time, you've been here for some time. Now, Ms. Braywood, I think before this meeting, Ms. North, sorry.
Sorry, Chair. There was just one final question, if Mr. Hughes could clarify. I understand that in the planning issues that were raised, that the licence holder was aware of a period when the conditions or the planning permission had come to an end, and then he was then required to apply but hadn't applied. So I appreciate, that the licence holder may not have been aware of something, but he would have been aware apparently of these particular conditions and the limited permission that he was granted at that time. So I don't know if Mr. Hughes can shed any light on that. And secondly, just separately, Chair, in respect to this meeting, I'm just conscious of time, that it's now 2016, and I don't know what time you're planning to end this particular application for the next one to start. So I don't know what your thoughts are on that. I'll leave that with you. Thank you.
So well, Mr. Hughes, can you?
Yes, as I said in my remarks, I assume Amanda is referring to the period 2011-12 when he had the temporary planning permission. If there's been a reminder to him since by a planning officer, then I'd be grateful to know when that was. But I can't assist the committee on that, I'm afraid, because I don't know everything that's happened in the last 11, 12 years. Mr. Selby will be able to answer that, but I'm not sure when it is said that he was made aware of the breach.
Okay, thank you. Mr. Tompkins, is it on this point?
There are minuted meetings in 2015 when there was an application for license review where Mr. Selby was reminded that is in breach of planning conditions. There are minuted meetings to that effect.
Okay, thank you. We don't have copies of those in front of us here, but Ms. Braywood, so what I think before this meeting you'd asked for 20 minutes for you to speak and your witnesses to speak. I don't think we've got 20 minutes. I think we've probably got 15 minutes. How do you propose that you divide up that time?
In all fairness, everything that's gone on is very confusing, as I'm sure everybody is feeling, and that's been the case for over 10 years. But what I would like to suggest is that I be as brief as I possibly can, because I believe that, and I stand by everything in the original documents, and I would like to give the opportunity to the witnesses to have at least a couple of minutes each to speak. Unfortunately,
okay. Before we do that, so who are your witnesses? It's Mr. Tompkins, is it?
No, Oliver was here at the previous one. It's Nick Bridges and Rachel Bowditch.
Okay.
Unfortunately, Kevin is working away and cannot get access to the meeting from the hotel that he's staying in. So he asked mindfully, to save time, that you would at least read the witness statement that he submitted.
So we have done so.
Which I'm sure you've already done. So, and be mindful of that rather than me repeat it and take up more time. So I would just like to take a couple of minutes just to answer a few things and then hand over to the two witnesses and try and remind them that they've only got 4 or 5 minutes each, if that's okay.
Yep. Thank you.
Oliver was able to point out the thing that Rupert had already been told in 2015, that there was planning irregulations and that irregularities, and they had been minuted. And obviously there is the confusion over the DPS situation. Byron Knightley was sacked on the 8th and he was promptly locked out of the premises. I have spoken to Byron Knightley and it is fully documented in the tribunal case that he took against Rupert Selby. So did not go back into that premises again by his own word of mouth to me and in the tribunal case that went on. So there wouldn't have been proper coverage for the DPS. Alcohol was sold in the first part of 2021. And I can go on. Most people have said things here, but I'm going to leave as much of that to the two witnesses. But what I would like to say is that from discussions over many weeks with all the residents and with members from the London Fields User Group, that we still believe that this premises licence should be revoked. We do not have any faith or confidence whatsoever in anything, and we've definitely not seen anything here with the way the case has been presented that from Mr. Selby, that there will be any change or any difference. At the last review, we were all mindful that we were going to have a discussion with mediation discussion, and that never happened. It was clear to all of us and to the many that were listening on YouTube. The messages are coming in thick and fast. So, but if it is mindful of this committee to go forward under the points of the conditions that have been drawn up, we beg virtually for no off sales, and we ask that it be 11 p.m. because we are aware that planning have confirmed with us, and that they will be bringing in a breach of conditions notice before the 31st of March against Off-Broadway and Mr. Selby, and citing the fact that he was reminded in 2015. And obviously that can be followed up. This was only brought to light because we as residents have done a huge amount of digging to try and find out what is and what isn't legal through the planning that was involved in the garden out the back, and that's how it came up and why it was resurfaced. And we probably feel that the council probably should have noted this sooner, but unfortunately they haven't. The other conditions that we're concerned about in this are that the outside seating table area, this is inherent a contradiction to the proposal. They don't have a license for the consumption of alcohol on the street, as it falls outside the scope of the licensing premises, as far as we understand it. So today the argument has to be that they are using the takeaway powers, i.e. alcohol license and off-sales space has been consumed, I think. However, if there's no off-sales after 7 o'clock, they shouldn't be anyone drinking outside after 7 o'clock, because they couldn't get off-sales to drink there. And as there's no license, and as they're not licensed for on-sales consumption, there shouldn't be any outside drinking anyway. I hope that's clear. Just sort of, again, I support the police in that we stick with the 4 smokers outside. If it is mindful to allow them to have off-sales, that we ask that that be restricted to a number of seating, numbered seated outside. In fairness, I would say, looking at the tables and chairs outside, that in all fairness, that would be between 8 and 10 in reality, given the benches that are normally there. And that's me being probably fairly generous, and my probably only time in this. We definitely don't see that there should be any vertical drinking, because that has been the whole reason behind all of the complaints that have led to this review. And we don't understand why that's in there, to be quite honest.
No vertical drinking outside or inside as well?
Sorry, outside. Outside. Sorry, I've lost my place now. Do forgive me for a minute.
Can Mr. Bridge come in now?
Just one last thing. Oh, I'd just like to also point out that we are aware that the shopfront trading at the moment, the license that's been allowed for Off-Broadway for a number of years has been revoked or removed or non-renewed. And Mr. Selby has appealed that, and it was turned down. And now I do believe, speaking to the shopfront licensing department, Derek Ferguson, that Mr. Selby is now taking that matter to court on appeal. So at the moment there is no shopfront trading, because they have breached their licenses on the shopfront trading for tables and chairs outside.
Okay, thank you. Mr. Selby, you've got your hand up, but we'll come to you after we've heard from the Mr. Graywood's witnesses. Mr. Bridge is the first of those.
Thank you very much. I'm ready to hand over.
Thank you, Louise. Thank you, Chair. It's Nick Bridge here. I just want to build on this evening's comment from the Chair and from the licensing lead, Mr. Gardner, that they're minded to revoke. And I just wanted to relate back to the previous committee discussion, because that had been preceded. It really is a bit more about the feeling of the residents. We've been incredibly tolerant. We like the market. We like liveliness. We like people to enjoy themselves. But we had over 25 complaints, all evidenced by video, of stuff going on way after midnight and noise and being woken from our beds and antisocial behaviour. I don't feel at the last hearing we really heard and really experienced what that's been like for residents persistently in that late night period. And of course, we're then woken up by the refuse bins, early coming to clear up all the rubbish from the back of those businesses. But this was a huge number of evidence collected from a huge number of people. Mr. Selby attacked residents. He's tried to single out so-called newcomers who don't like to have fun or don't like a market. These problems were coming from people very aged people, suffering people, people with 40 years on the street, 30 years on the street, one of whom's left the street because they can't stand it anymore. And I just want to sort of remind us that at the beginning of last week of the last hearing, Mr. Gardner had said that despite, you know, all the police action, all the authority action, the hundreds of hours we've put into this single issue collectively, paid for out of taxpayers' money, paid for by our council taxes, he said, quote, "Problems have persisted, further complaints continue to be received, the premises are a blight on our local neighbourhood, the licensee has not demonstrated an appetite to change its behaviour despite all this authority engagement and has demonstrated poor character, and I've got no confidence in his ability in the licensee and feel the licensing committee will have no choice but to revoke the premises licence." So that was before all of this discussion of DPS and whether he has a personal licence and all the illegal trading post 11 p.m. that's been going on and that was brought to his attention in 2015. So the thing that we fear is that if we don't revoke and we just have new conditions, we get to a hot spring, a hot summer, a hot autumn, and we all have to go through this again, providing hours of evidence, getting out in our pajamas, going down the street, being abused by the drinkers and abused by the noise and on our old people who live next to the bar. I mean, I'm at some distance from the bar and I'm woken in my bed with earplugs in on numerous occasions through last year, and I sleep pretty well. And Rachel here is about 10 meters away. And I just feel that there's been, you know, if we don't, I hate, this is nothing personal, but if we don't revoke this, given all the activity and lawful activity and behaviour, and the lack of any confidence, there's been no consultation with neighbours, no desire to engage with our concerns, or the beer garden issues. If we don't revoke on this basis, on what basis would one, you know, revoke the licence? So it gives me absolutely no pleasure to do this, but I don't, you know, I hope I'm conveying, I think, on the part of a wide number of neighbours, and that this for us just feels like it's going to start all over again. And I don't think we've got any evidence that it would be any different. I saw in the evidence to this committee finally that the number, I think it was 9 occasions when Mr. Selby said things that were simply not true in the last committee meeting. And I think we've heard some other issues this evening about when, you know, he did his DBS application. It's different to when he said he did it last time, and it just feels like he's making it up as he goes along to try and sort of hold on. So I just fear that we don't have somebody we can, you know, really engage with, and it's a very demoralising situation. There are wider concerns about a lot of drinking and a lot of antisocial behaviour on the market, but this is a particular issue that has caused us strife. So thank you very much for the opportunity to make those points, Chair. Thank you.
Thank you. And we've seen lots of evidence of antisocial behaviour and nuisance emanating from this premises, and the committee subcommittee will take account of that. Ms. Bowditch.
Yes, thank you, Chair. Just one moment. Okay, so Chair, 3 to 5 minutes, please. What I'd say is that the measure of a licensee or someone's character is not how they behave when they know that the police are watching them and when licensing is watching them intently. It's how they behave in the everyday. The standard of behaviour we've seen when there's been a tight focus by licensing and the police gives you, I think, an indication of the behaviour that we have experienced in the everyday. If we have a scenario where the police and licensing themselves are saying that Mr. Selby has failed to properly engage with them and pay attention to them, then you can imagine what it's like for us as residents. When it comes to a situation where one's licence is potentially up for revocation, you think you would pull out your best behaviour. You'd pull out your best cards, and you'd make sure you'd have all your ducks in a row. If, for example, during the lockdown period, you made about 50k profit, about 10% profit on your revenue for that year, you think you would be able to afford 4k for mediation fees. You'd also think if you could not afford 4k for mediation fees and you had a venue already in which you could host events such as a community consultation, which Mr. Selby did in relation to Planet Organic opening further down the street, you think then you could call a community session to discuss licensing and the behaviour of venue and how everyone could work together. But no, that was not done. Instead, fees have been spent on further legal fees for today, legal fees against the revocation of the shopfront licence, and I'm sure further on legal fees for other activities. But in the midst of this, there's been no ability to consult with residents. As was very clear, as Councillor Peters said, Chair has said, was a clear guidance from the last session that we're all in. In relation to actually what the licence is and what the planning is, it is very clear that currently there are no off-sales licences allowed except for under the COVID exemptions. They expire in a few months. As a resident, I say no to any off-sales. Full stop, only on-site. There is currently no shopfront licence, but tonight, once again, there are drinkers out there with glasses from inside the bar. Unfortunately, I couldn't take a photo as my 5-year-old was with me at a time, and it'd be fairly obvious me taking a photo of that. So even today, on the day when this hearing is taking place, we see clear breaches at the bar. And for Mr. Selby to imply, or his lawyer to imply, that Mr. Selby thought that he is adequately covered by the DPS position in place of Byron Knight, when actually in an employment tribunal, it is noted at a legal hearing that Mr. Selby changed the locks. So Mr. Knight and the rest of the staff at that point could not re-enter the premises. The reason for Mr. Selby doing it, as quoted in the employment tribunal and as evidenced in emails from Mr. Selby, is because he was aware that the staff at the premises were keeping the premise open after 10 p.m. He told them at the time that that was completely illegal, and how dare they do it at the time when he was due to have his next child, and basically put that pressure on him. This in 2020, Mr. Selby told staff that they had no license, no ability to sell alcohol on site after 2200 hours. We also know in 2015 that the licensing informed Mr. Selby about planning irregularities. The minute reference for the recording is licensee subcommittee hearing 11th of June 2015, minutes 6.15. So I'm slightly aghast that we can get to a stage tonight where we're still wondering really what's going on when Mr. Selby fired effectively his DPS because he was allowing sales after 2200 hours. So as a local resident, I would love a great bar literally on the corner, which I could just walk out my door to. But I would love a great bar to be run by a licensee who understands his license and has the intention to abide by his license, as the intention to communicate with his local residents. Unfortunately, in the current situation, we don't have that, and I wish him the best of luck, but I can't support the maintenance of a license under the current licensee for Broadway.
Okay, thank you. Right, so I propose that I give that Mr. Selby and Mr. Hughes, you have 10 minutes to respond to that, and then we'll sum up and the subcommittee can consider what is heard tonight. Mr. Hughes, Mr. Selby, how do you want to divide up your time? Who wants to start?
Well, so I probably hand the floor to Mr. Selby. I've talked a lot here so far. So some of the allegations are against him directly, and I know he wants to answer them, particularly in relation to the 9 lies that were referred to earlier. Might just comment on Rachel's comment there about legal fees. He's not paying an enormous amount for legal fees. I'm actually charging a fraction of what I would normally charge on these kind of cases, because I know that he is in dire straits, and of course the pandemic has not helped anyone. So I've been losing money, if you might want to put it in that way, since probably December on this matter. So I've agreed a fixed fee with him, and it's a fraction of my normal charge out rates.
Okay, Mr. Selby.
Okay. Rather than addressing all the written points, because I think that'll take us all night, I'm just going to respond to the oral comments that were made in the last few minutes. Louise Brewood mentioned that I'm going to bring this up several times, the tables and chairs license outside is invalid. It is not. There was a hearing in January, which we were exonerated in, and the license was renewed today. I'm happy to provide a copy of the license from Hackney Council that was issued this afternoon. It would have been issued last week, but their computer systems are down again. It expires on the 21st. The new license is valid from the 1st of April. So there's never been a point where we don't have a license, and Mr. Fergus held a meeting with me and my legal representative, who was a member of my staff, who acted pro bono, and we were shown to have been a good provider of tables and chairs situation. Every single premise in Broadway Market with tables and chairs outside, of which I believe there are 10 at the moment, serve alcohol to the customers outside. It's always considered as part of your premise. I don't think anyone's doing that on the basis of an off-license trade. It's very much an on-license business. So I disagree with that point. But we do have a tables and chairs license anyway. In response to Mr. Bridge, I haven't had any reports of any complaints about noise after midnight for many years. The bin collection, which may have been causing problems several years ago, was of course completed by Hackney Council's refuse collection, and that service is entirely provided by Hackney Council, and I apologise if they were making a noise. We realised it was an issue and have moved to a rubbish bag situation, so that hasn't been the issue since I believe November 2021. And in response to Ms. Bowditch, right, we didn't make £50,000 at the beginning of the year. We did make some money, which was very helpful. Like most bars in the United Kingdom, we're barely surviving, and it's incredibly difficult to trade at the moment across the UK. Thank God we're insured for COVID, so that's managed to pay off VAT bills. I dread to think what's going to happen to a lot of people when VAT comes liable at the end of this month. I think there's been some confusion about the idea of mediation, which I was very keen on when I first met with Hackney Licensing with Mr. Hughes some months ago, prior to this, the first meeting. It was my understanding that we contacted Mr. Hughes because we couldn't, of course, know which neighbours would like to speak to us because all of their evidence had been redacted. And I believe that Mr. Gardner was going to organise mediation. That was my expectation, insofar as collecting the names together, because there's nothing that either Mr. Hughes or myself could do to contact people. I mean, obviously, I know Rachel, and I know Mr. Tomkin from next door, and various other players. I've never met Mr. Bridge before, and obviously I know Louise. But because all their evidence was redacted, we left it at the end of that meeting that Mr. Gardner was going to approach the interested parties and see if they were mindful to have a meeting, either in a formal mediation setting or a more informal setting at the bar, which obviously I prefer because we're all neighbours and it's easy and nearby, and I don't think anyone wants to traipse into London. Nothing came of that, and obviously I think that's been so much of a shame from all the comments today, but there we are. Just to repeat, there's been no revocation whatsoever of our shopfront trading licence at any point. We've had a shopfront trading licence. And any information you may have had to the difference is not correct, and I can supply copies of the licenses if required. We've had off-sales license at Off-Broadway since 2008, December the 6th, 2008. I don't remember having any specific complaints about off-license trading. The point that Kerry, the Metropolitan Police make is that there's been tradition of people talking to people sitting outside of all bars. And this has been a problem for the Dove historically and the Cat and Mutton, and now in recent years, but not at the moment, my bar, in the fact that you have people buying takeaway alcohol and then communicating with people who haven't bought takeaway alcohol. And we had a long discussion about this at the recent meeting with licensing and the police, and that's agreed to stop any takeaway sales, so that we can be in a situation where anyone outside the bar after 10 o'clock can easily be identified as not one of our customers, because it's very important everyone to realise where the level of responsibility lies, whether it's for us to maintain our pavement or for others, wherever possible. And that was agreed at the time with the police, but obviously that's gone somewhat further now to end that licence at all. At the meeting, we identified a cut-off point at 1900, because during the summer months, people like to buy spritzers and other lightly alcoholic drinks from our bar, and we've done a good trade in those for many years on a Saturday. Many other bars do takeaway alcohol sales from their windows, particularly the large chain Franco Manca do takeaway beer on a Saturday. In regard to the dismissal of Mr. Knight and several other members of my staff, but by no means all of them, I found out while I was on paternity leave that they had served alcohol late on the last day before the lockdown. I was aghast, took immediate action and dismissed everyone in my employ who was visibly seen on CCTV. Not serving alcohol, but not. There was an absolute lockdown of 10 o'clock where the bar had to be vacated. And for 20 minutes, they didn't move customers out on this last of the most important of all days. So I took immediate action and dismissed everyone. That meant that I had to hire in a completely new team of staff when we reopened on the Tuesday, what was then off sales. And in all the pandemonium, and again with a very small child, I tried to fill in all the forms and dot all the I's as quick as possible. But during the time, obviously, it was quite a very busy period for everyone in whatever field of life you followed during those hectic months. Yes, I completely admit there was a delay of a month where I should have filled in the form more quickly, but I did not do so, and I apologise for that fact. It was a heady time. There are various other printed statements which I find deeply objectionable, but I don't think it would be helpful here to discuss them.
Okay, thank you very much. Mr. Tompkins, you've had your hand up for a while. Is there something you wanted to
I just haven't had the opportunity to speak. I know I spoke at length during the last hearing, so I don't need to speak at length and take the time of the committee, but I just reflect on what's been said, and I do wonder what a licence holder has to do to lose their licence in Hackney. I think I'm also very sympathetic to local businesses. I want them to do well, but I think Mr. Selby's proven himself to not be a suitable person to hold a licence, and I think there's a lot of kind of excuses for various breaches. There's been multiple planning breaches, and it's been the residents that have had to highlight all of this, and it's taken a lot of work from all of us to bring it to this point. And I have no confidence at all that Mr. Selby will cooperate with us in the future. I've had kind of no attempts at mediation as suggested, and whenever I've reached out, it's been rebutted. I simply fail to see how this can be addressed by amending the conditions. I think we have to think very hard about the suitability of the licence holder.
Thank you very much. Mr. Selby, do you have anything that you would like to say in response to that? You don't have to.
Sorry, yes, I don't know what went wrong with the mediation. It was discussed with Mr. Gardner. It was agreed that it was a good idea. It was supposed to go forward. I suggested to Mr. Hughes that I would rather do it in a more informal setting at the bar. I believe this was forwarded to Mr. Gardner. I can't confirm that. And nothing seemed to happen. I think that it's remiss of everyone involved that we haven't been able to sit down around the table. Obviously, I'd be the principal player in that, but we are all, I don't think I'm more than 6 foot away from Mr. Grocott or Mr. Tompkins at the moment. I can see Rachel's house in the background. Louise is about 300 yards away at the end of the road. We're all on top of each other. And in order for us to proceed and go forward, it's important that we're all very happy with the situation. There are many loud bars in the street, and I'm one of them. This is in a different location, Captain Martin, obviously, and it's very important that we manage to make our lives together as peaceful and harmonious as possible. I very much welcome, and one of the suggestions that wasn't brought up in the new conditions on the license was that we had biannual or by 2 times a year it's a condition of the license that we have a meeting with the local residents. I think it's an excellent idea to try and work out how we can work more harmoniously. Obviously, in these straitened times and shocking times, it's a bit of a shock for us all to come out of recession of the COVID restrictions. But I'm sure that there's a way that we can make this work better.
Okay, thank you very much. So I'm really keen for us to move on now, and for Councillor Vagina Thomas and Councillor Root to ask anything they need to ask. Mr. Grocott, you've got your hand up, though.
Just because I haven't had a chance to have a say at all, I'd just like to call Mr. Selby up on him having no noise complaints after midnight for a few years. I, in fact, emailed you last month after midnight saying there were noise complaints, of which you passed me on to your manager rather than engaging in any mediation at all. And I found that really disappointing after our last meeting, and this was in the intervening period, that you obviously had my email address and you still haven't reached out to me at all. And you were quite dismissive and passed me just to your manager. This whole process has been really exhausting for all the residents. And I think you can see that we've really just lost faith in Mr. Selby to stick to any conditions. It's gone on for around 2 years that we've had to collect all this evidence, come from multiple meetings, hundreds of emails. And I just found it very exhausting to continue. So I just want you to bear that in mind, that we really do have faith that any conditions will be abided by.
Thank you very much. Mr. Selby, you'll have an opportunity to sum up in a moment, but Councillor Vagina Thomas.
Thanks, Chair. I'll be very brief. It's just to ask Mr. Selby, you mentioned this, which was part of what we discussed and when we adjourned this hearing in January, to have the opportunity to engage with local residents who's come forward. But you are saying relying on the council, relying on Mr. Gardner to help do that. So I find this strange, because it's not the responsibility of the council to help you as a licensee to engage with local residents. And secondly, you mentioned the reason you have not been in touch with people because you don't know them, but you still mention 2 names, people that you know. Even reaching out to those people saying, oh, I don't know the other people on that license hearing, but I know the 2 of you. Are you able to get in touch with them? Let's have a community meeting in the pub. Let me let you know where I'm coming from and how we can work things out as neighbors. So if you are saying, if you haven't done all of that and now saying you think Mr. Gardner would do it, again, I find it a bit strange, or just my thought on that. Thanks, Chair.
Thanks. We collect Councillor Root's comments and questions as well.
Thank you. My questions really are just what Mr. Selby thinks of the revised conditions that we've been talking about here. So essentially at this point, the revised conditions are looking to me like there would be no vertical drinking outside at all. There would be 6 to 8 seated customers outside up until 10 o'clock at night. There would be no off sales. There would be closing at 11 o'clock at night and only 4 smokers outside. Those are the sort of things that have been proposed by the police and by the licensing authorities. I wonder if Mr. Gardner, if Mr. Selby would be willing to agree to all of those conditions.
I would. We suggested a restriction in off sales, mainly due to people congregating outside and defining who our customers are when they're outside of the building. I would like that to be only weekdays. I would like to have some off sales at the weekend, because obviously I'd like to make use of both the Saturday and now the new Sunday market up until, say, 5 o'clock, but not sort of any time that's going to disturb anyone. We suggested 7 o'clock initially, but we could come back early because the stalls pack up at about 5. Sorry, I'm just going to go. I didn't get an opportunity to note down your points. The tables and chairs outside, we suggested 10 to 12 people outside. I'd like to say we can seat, this evening we had fully seated 10 people outside in comfort. 10 would be where we'd like to be with the benches outside. They are 2-3 metre long benches, so they're quite long. That's within our boundary of our licenses, a 6 metre by ½ metre restriction on our tables and chairs license. As regards to the closing time, I'd just like to say that I'd like the closing time to be in line with the planning permission. If we're going to do it that way. There's a Cat and Mutton closes opposite us, fewer than 100 feet away, at midnight and at 1 o'clock at the weekends. Most of the local restaurants serve until midnight. It confuses the public, and obviously we would like to serve later. I haven't had any complaints about noise after midnight. The previous comment from Mr. Grocott, he got the time wrong, unfortunately. The decibel meter, and there was a problem. A door was opened which should have been alarmed, and that's our mistake. But that was 11 o'clock. We haven't had a consistent problem with noise after midnight, and you can see that if you go back from the complaints. Most of the complaints from Mr. Thomas and Mr. Grocott, in fact, all of them refer to people drinking outside after 10 o'clock. We've never had a problem with our licensing laws. We've had a license till midnight since 2011, and at no point that I know have we'd had a problem with noise after midnight. And we have on occasion, and we've always served alcohol during the days at the weekends, and recently to help up trade and to support our food offering, we've been opening during the days, but it's not a big trade and wouldn't make much of a difference if we stopped that. I don't think anyone here has got a big issue with what we're doing until 4 p.m. But I think that if we're going, the confusion between planning and licensing is, I look to licensing. I don't think there's an issue between 11 and 12. And if you've got a pub over the road, all that's going to happen is you'll have possibly 60 to 70 people marching across to the Cat and Mutton or further on to the pub in the park at 11 p.m, which I don't think would be desirable for me upstairs or any of the neighbours, because dispersing people in a regular way down the street doesn't lead to peaceful evenings.
Okay, thank you very much. I think we are at the end of the discussion, unless Councillor Ruth and Councillor Vagina Thomas have anything to say, and there was a chance for people to make closing remarks. If Mr. Tompkins and Mr. Grocott have anything they want to add, and if they could be very, very brief, that would be appreciated.
I've clearly submitted multiple noise complaints past midnight by email to Mr. Selby and to the council since the last hearing. He can say that that's a lie if he wants to. I was awake till 1:30, listening to the music from his bar. What can I say? That's it.
Okay, thank you. Mr. Grocott.
Echo that. I was not mistaken. It was after midnight, and I emailed you after midnight when the noise was ongoing. Thanks.
Cool. Mr. Bridge.
There's numerous video evidence of after midnight, so to have Mr. Selby directly challenge that is remarkable. We've got all the evidence, we've got more that we can provide if there's any doubt over that, but it's all gone to licensing over a 2-year period, and not to Mr. Selby, who I personally haven't engaged direct. There's evidence of late, beyond midnight, number of times, noise, unmanaged, serving after midnight, and so on, all on video. Thank you. I can't believe Mr. Selby's just summed up in that way. Thank you for the last word from me.
Ms. Braywood. You're on mute.
Apologies, sorry. I just wanted to add to that you do have video evidence already submitted, which confirms that they were serving alcohol after that time. Would also like to point out that we were informed that Mr. Selby would be allowed to use his shopfront licence until the appeal hearing that he has lodged for that, as per, is allowed, because he does have an ongoing appeal for that with the courts, and so under those conditions he's allowed to have the chairs and tables out until that time. So that's obviously, you know, what we've been told from shopfront trading, and given that I have attended many of these licensing hearings, up and down the street and reviews and various things in the area. And given that with my bald hat on, for the Safer Neighbourhoods, I've worked very closely with all what goes on at Shoreditch, and it is definitely agreed that staggered closing times does add to dispersal in an area and minimise impact on residents, and it is now being employed across Shoreditch. So it's not something that I feel that we should disregard here. I think we should include the possibilities of different closing times. Thank you. Thank you very much.
Yes, sorry about the stuff in the background here. It's just, I'm still a bit concerned about this DPS point. For something that is so really serious for a licence, and to create a situation where your DPS is not allowed back on the premises, you physically changed the locks. This does concern me. And it was very opaque about when applications were lodged, someone else's name, credit cards. If you're on top of stuff and treating this process with respect, you would have all those records in front of you. That is all I will say on that matter.
Thank you. PC Ryan.
Thank you. I'm just going to cover a few points. So its applications obviously, without doubt, drawn considerable support from the local residents and from responsible authorities. It's unfortunate that the status of the DPS is frankly a mess. And it does cause us to question the processes that Mr. Selby has said that he's completed in relation to varying it since Mr. Knight's employment was terminated. As an experienced licensee, he should be aware of the procedures and processes that are required to be completed. So we will await confirmation of the credit card payment that will show that he has not been operating without a DPS since November 2020, when Mr. Knight was banned from the premises. In relation to the conditions, the conditions were drawn up to be used in the case of the committee being not minded to revoke the licence. I've been through the amendments that the police would like to see, and I echo Ms. Freewood's comments in relation to the vertical drinking in the streets, in the sense that the vertical drinking is one of the biggest factors concerned in bringing this review. Off sales at the weekends are the biggest problem. On a sunny day in summer, we see huge crowds in Broadway Market. Not all drinking from off licenses. We have seen crowds outside off Broadway drinking in open containers from there. The amendments would allay our concerns to a degree, but our confidence in Mr. Selby is not as high as it should be. I don't feel that Mr. Selby's made enough effort to engage with the residents. Yes, they could approach him, but this is his licence, his establishment, and his livelihood. So if it's so important, why hasn't he made the effort? And as Mr. Selby stated, he said there's a way to work better together. Why hasn't he done this before today's hearing? It's a little disappointing. I'll leave it there. Thank you.
Thank you. Mr. Gardner.
Thank you, Joe. I don't really have anything further to add, actually. I think you've heard sufficient from the residents, police, and myself on this particular matter, and I'll rest there.
Thank you. Mr. Selby or Mr. Mr. there? Sorry. Mr. Hughes. Do you have anything that you'd like to sum up with?
Are you still with us?
Yes. Thank you, Chairman. I don't know whether Rupert needs to sum up or me, but I'll say my bit, and then he might want to add a few words at the end. Just very briefly, because you had a lot of evidence in January before you, and at that hearing I asked you as one of the key things to look at the context in which the confusion of the last 2 years has taken place with the pandemic and all the various regulations, and I explained at that meeting about the confusion that even hard-nosed lawyers like me had, and I was trying to interpret these regulations on behalf of the Institute of Licensing and others, along with other counsel, and we were literally scratching our heads sometimes on the phone to each other late at night trying to work out what they meant and the implications for them. So it was a confusing time for all. 21 prohibition notices were served, we heard, in 2020. It's in the papers. in front of you, not just Mr. Selby, but 20 other premises on that occasion too, by the police. We'd ask you to look at the fact that there are no representations here from the environmental health noise team, from health and safety, and particularly from the planning department. We've heard a lot about planning tonight, and I've addressed you on that particular point, but we don't have an objection from the planners, sorry, I shouldn't say objection, a support letter from the planners to this review application. We hear they may be doing things elsewhere, but that has to take care of itself under the planning regime. As I said in January, the bulk of the complaints, it seemed to me, that Mr. Gardner had placed in front of you were relating to the rear garden area, and they accounted for a lot of the complaints, and that matter was effectively, well, people are nodding, but they accounted for about 16 of the complaints, I've counted them myself, that Mr. Gardner has put in front of you. One can count them oneself, but they're there, and that has now been subject to stopped and subject to a planning application, which I think has subsequently been rejected in any event. So that matter has effectively been terminated. But I told you that it was a long-standing operation here. Mr. Selby and his father, Mr. Selby Senior, who were both the license holders on this premises, came before you last time, and they had set out how many years they'd been living in this area and contributing to it. And it is. Mr. Selby's been accused of being a liar, but he has been here for 40 years, possibly even close to 50 years, I don't know. And Mr. Selby Senior for even longer. And so I'd ask you also to contrast the evidence you've heard tonight with the substantial body of residential support there is for Mr. Selby. You've got 85 representations in your papers. I know that some of them are in different postal areas, but a lot of them are in this postal area, and many of them live in close proximity. So the problem is, of course, because and people are nodding because they simply don't know where these people live. We know they're in E8 because they're all redacted. So we don't know who they are, but we do have their addresses and postcodes, and we know that they are very close to the premises. And a lot of them have taken the effort to write in personally. They didn't do a standard petition, although I think there was one, but they have written to the committee personally asking that you keep this premises alive. So I think as part of this process, Mr. Selby has actually proposed conditions on his own licence. One of the colleague councillors said last time it might be a good idea to look at other conditions on other licences in Broadway, which was a rather good idea. And of course, I went to have a look at the other conditions. Of course, you can't access the licensing register at Hackney at the moment. So it's very difficult to draw those licenses down unless you ask the licensing officer for copies of 20 odd licenses. But I think that the conditions that we've come up with here should at least satisfy the committee that Mr. Selby is taking a responsible approach to this, and that you've heard what he said about the conditions. Many of the things that he's said tonight are in agreement with the police, Mr. Gardner, in terms of the amendments to be made to those conditions. But it's a pretty comprehensive list of conditions that we submit is in front of you. So, short of that, we have the nuclear option that you've got of revoking this license altogether. As I say, you are entitled to consider, you must consider the 4 licensing objectives, but you are entitled to consider the impact on Mr. Selby, his family, and all the employees at the premises who will be out of a job if the license is revoked here. So we would ask you to look favourably on the conditions that have been proposed and agreed this evening. It's a comprehensive list, and if you are minded and your colleagues are minded, we would ask you, sir, to attach those to the licence. There's just one other thing I need to clear up, and that is that a statement was made in one of the redacted statements. Again, I don't know who made the statement, that I had somehow misled the committee on the last occasion. I'm not in the business of misleading committees, but it was said that I quoted the wrong hours of opening for Broadway wines, which I understand is opposite to Mr. Selby's premises. I do note that I said on the video, I think I said I understand, but our list shows that Broadway Wines has a 2 a.m. license on Friday and Saturday evenings, albeit that it's earlier in the rest of the week. Now that's our list, but I haven't been able to access the Hackney Register to see if that is actually the case. But I just wanted to clear that one up for you, Chairman.
Yes.
Mr. Selby may have something to add.
Well, just on that, and we certainly don't think that you misled us. And
I'm grateful.
Mr. Selby, if there is anything further that you want to add, and if you can do so briefly, if there is, then we would be very, very appreciative.
We've lived here for a very long time, as we've stated. We ran a bar for 10 years from 2008 to 2018, 2019 with very few problems, mostly harmonious existence with our neighbours. Since COVID, we've had issues along with many other premises in the country, and I think this has come to a head due to a lack of dialogue, and that's a problem which is mostly mine, but obviously on everyone's behalf. And I hope that with some dialogue, we can see the harmonious running of this bar as a feature. We got 500 emails of support and over 100 written letters that I submitted to the Licence Committee in support of the bar. And until I took the petition down, as I was asked to by Kerry Ryan at our last meeting, they were coming in daily. People do love this bar, and it would be a shame to see it go. Not regarding what Mr. Hughes said, obviously the massive impact it would have on my family, my very small children, and my 8 employees.
Thank you very much, and we'll take all that into account. Councillor Chandler Thomas and Councillor Reid, is there anything further that we want to ask anyone?
No, Chair, thank you.
Councillor Reid?
No, I'm happy as well, thank you.
Okay, in which case I'm going to call that item to a close. We will, I think, have to deliberate in camera, and we will let you have our decision in short order. I think we're saying within 5 working days, although the licensing officer can tell me if I've got that wrong, and certainly if you want a indication of the sense of the decision, then you can call the licensing service tomorrow. Thank you, everyone, for coming along. And now we're going to move into agenda item 6, which is about a personal license, which will be held, which will not be held in public. But before we move on to that, let's say if people want to leave the meeting, then feel free to do so.
Thank you. Good night.